Hello everyone and welcome to today's learning session, National and Subnational Legal Frameworks for REDD, organized by World Wildlife Fund's Forest and Climate Program. Thanks for taking the time to join us. My name is Breen Burns and I'm a Program Officer for Learning and Communication. Our presenter today is John Costenbader, a Senior Consultant on Forestry and Carbon Markets at Climate Focus. So before we begin, I'd like to share a few housekeeping tips and reminders. Today's presentation is being recorded, and you can access the recording within a few days on our YouTube channel. To find the recording, simply go to youtube.com and search for WWF Forest and Climate, or go to panda.org/forest climate and look for the REDD learning section. There are two audio options. You can listen via your computer speakers, or you can dial in through the number that was provided in your registration email. It's important to keep in mind that if you experience audio difficulties while listening via your computer speakers, this is sometimes caused by having too many software or internet applications open. So feel free to close some of them, and that usually solves the issue, or you can always join us via phone. If you are having technical troubles, please send me or Jenny Guzman a message via the chat area if possible, and we'll try to help you get it sorted out. Questions are absolutely welcome. Please submit your questions for John through the toolbar on your screen, and we will answer as many as possible during our allotted time. For anything that we don't get to cover, you're invited to post them to our online REDD Plus learning platform, reddcommunity.org, and after the webinar, you'll receive a link to the place on the website where you can post those questions. It's going to come in your follow-up email. So we'll also post a link to the recording of the session there so you can access it after this presentation. So thank you again for joining us, and without further ado, I will turn it over to John.
Thanks, Breen. Hi, everyone. Good morning, good evening, wherever you are. My name again is John Costenbader, and I work with Climate Focus on basically law policy issues, largely around climate and forest and land use types of issues. Today's focus, as Breen already mentioned, it's on largely I'm going to talk around national legal issues, and I've divided them into these buckets here. But we'll also talk a little bit about subnational and mixed type approaches, as these are kind of more emerging issues that could be of interest as things progress with REDD, and in the interim until a global framework. I'm just going to, right at the top, I'll start a little bit out. Actually, Breen, if you want to go to the next slide. Well, actually, the next slide is a little more intro. So this is more intro, just about who I am, who my company is. I don't know if you haven't heard of Climate Focus. We're actually based around the world. I'm based here in Washington, D.C., and we have colleagues in Amsterdam and Bangkok, Bogota, Lisbon. So we have a land use office here in D.C., but we also have, some of my partners work on, or my teammates work on, more standard emissions reductions projects, programmatic issues. We have a lot of work out in Asia on forest, lowering emissions in Asia's forest, the LEAF program, and yeah, that's about it. Clean development, emissions trading. So again, this talk is based largely around work both at literature type research and reviews of legislation that we've done, both at Climate Focus and other work experience, but also working directly with countries on developing or reforming their legislation and regulations around REDD and land use law. So a little intro here. I know probably everyone here, and it looks like we have a big range of participants in terms of experience, some very advanced probably, and some maybe new to this topic specifically on either REDD or the law for REDD Plus. But just to set the stage, I mean, probably everyone knows that forestry is a large component, 17% of overall emissions. And this is from 2004 IPCC data, the AR4 report. But overall, if we think about going towards more of a landscape approach, as things are expanding, then we think about 30% for the agriculture, forestry, and other land uses overall sector. Sorry, these acronyms, in case you're new, land use, change, and forestry is the LULUCF acronym. Horrible acronyms, I know. But when we think about the law and regulatory frameworks for REDD+, it has some of the similar challenges as REDD+ in general and a lot of these type of incentives frameworks. How do you find something that's functional, effective for the climate and environment, that's equitable and just for, especially for rural groups, and measurable and efficient. But it's also this extra question that pops up at the end there: how to make it simple and easy to use, not overly complicated. This is a big challenge, I think. And along with simple and not overly complicated is clear, in order to give the right signal to all parties. We can proceed to the next slide, Brian. So first, oops, actually went to, there you go. The first issue here, or first part, I'm looking at just national level issues. I've divided them into these 4 groups, which you can cut this orange in many ways. But I thought this is a good way to think about regulatory frameworks for REDD. Think about types of issues that are important. One is more, the first one there, rights, is more of a substantive issue, whereas this number 2 and 3 are more procedural and cross-cutting. But rights is really kind of a fundamental starting point, I think, and it's a major challenge if we don't figure out figure out, for example, a lot of cases it's hard to figure out who owns or has access or use rights to certain areas. The tenure issue. Then there's also the issue of carbon rights. We'll get into both of those. And then 2 and 3, I think design and implementation and enforcement. This is kind of starting from the original idea of the policy idea and developing it into law, and then taking it all the way through to implementation and making sure that coordinates beyond the forest sector to all the other sectors that are relevant. Public participation is the guiding kind of the railroad tracks for REDD, forest governance, for like it should be for all kinds of law and policy reform and development. So it's important we get those right, and it's especially difficult given that we're talking about really remote areas a lot of times, and diversity of actors. And then this final bucket I have here, number 4, which is I called it crystallization. This is a term we use sometimes in law to talk about when you have issues that have developed, and then you want to kind of, it could be codified, it could be it could be put into other types of legislation or regulations. But it's basically taking these policy decisions and putting them into a clear framework that that everyone can understand. So well, I'll get to those issues in a sec. Let's start with rights and tenure. And first, tenure reform, it's a huge issue, like I just mentioned. It largely revolves around conflict and confusion around the scope and ownership of rights and those who possess rights. And this can be confusing a lot of times in countries that are developing REDD+, because they may have different systems of formal statutory recognition and then the informal de facto rights, where what is actually happening there on the ground. And there can also be traditional rights which are not given de facto recognition. So there's maybe traditional or customary rights that are not recognized on the ground for whatever reason. So this kind of recognition and reform take a lot of time. So, in most cases, if you think about the case of Mexico, I believe Mexico revised its land tenure system. It took from 1915 until 1992. So, or maybe I'm off a few years, but we're talking about a large amount of time, and it's as important as tenure is. It's something that we can't say it's a prerequisite, or that it should be clarified completely before REDD will start, as much as it is a very important issue. So tenure is something that we can think about in terms of putting it on the agenda, getting it started, but we can also think about short-term workaround temporary solutions, so that we can, for example, streamline recognition of customary and informal land title, compensate communities more generally for their efforts rather than to individual landholders, and then the long term think about harmonizing statutory or legislative tenure norms and customary norms. In the second issue, which is closely related to tenure, carbon rights, it's hard to have carbon rights sometimes if you don't have the tenure, because they're connected. But like I said, tenure is a long-term process, and in the short term, may be important to have some clarity on what actors need, especially relevant to what actors are being reimbursed or are being incentivized for their performance. So there's 3 ways you can clarify carbon rights, more in the short term. In the first case, you can have explicit new legislation addressing carbon rights directly. And this is the clearest solution and the most enduring. But on the flip side of it, it can take a bit of time, because it's a complicated decision, first of all, to think about legislation that covers all rights holders and landowners, and when and how this should be granted, especially in light of the tenure situation, of the overall rights of ownership, access, and use to land and forests, for example. So then the second form of clarifying carbon rights is by interpreting existing legislation, and this is a quicker solution. It's usually a temporary decision. The government interprets existing legislation, for example, existing forest legislation, saying, for example, if the legislation says the owner of the forest is the person who manages the forest, or the person who receives the benefits is the person who manages the forest. That's a way to interpret existing legislation. But it can be unclear because if the executive decision or the government interpretation is overturned later by legislation from the legislative branch, or a different government ruling later on. So it's helpful to have guarantees up front that if there is a reinterpretation or legislation overruling the temporary interpretation, that either the landowners will be compensated, or there'll be some other recourse to for the people that are relying on that interpretation. And the third carbon right kind of clarification I put out here is by contractual agreement. So this is a helpful. Of course, people that are investing in carbon contracts are going to want to have an agreement that runs with the land. So that means that it's for example, a conservation easement, something that that is not just a contract between the people, but it connects with the land itself. And so this would require generally registering the contract or the instrument as real property, land property, as opposed to a personal property type of contract, which is more difficult to enforce. And that can take a little bit more time, potentially. It has a little more complication. But this is also pretty standard in terms of a lot of private projects. One last thing I guess I can note on the carbon rights issue is if you can go back one, Breen. Sorry. So one last thing is this is also relates to the workaround issues, because tenure is a long-term process and land is usually connected to the carbon tenure. It might be helpful to divide land in a given country or jurisdiction between the areas that have secure tenure with give those areas full carbon rights, and treat it as carbon rights specifically, and then areas where the land tenure is unclear and the rights are unclear, then arrange for equitable kind of benefit sharing arrangements that aren't tied directly to the land rights, but where people's their efforts can still be incentivized regardless. Thanks, Breen. So this second issue at the national level that I like to set out here is it's three issues, but I see them as progressing in step in like one complete motion. So starting way back in the beginning of the creation of the policy framework that leads to the regulation, there needs to be this overall perspective of all the legislation and all the sectors that are relevant to REDD. So this isn't really this should not be seen to be, and actually this whole presentation is not really about REDD law per se, but rather the entire framework of law that is relevant to REDD. Because if you're just discussing REDD in isolation, when the drivers of deforestation and forest degradation are coming from, for example, the transportation or the mining or infrastructure type sectors, then it's going to be hard to actually do much about REDD beyond just maybe short-term incentives that change behaviors temporarily. There needs to be a harmonization and simplification of this legislation across sectors. And a lot of times what happens is countries develop, they add more layers of legislation on top of existing legislation. And so you might have a beautiful new REDD law on top of a lot of laws that are confusing and in conflict with it. So that beautiful new REDD law will not actually do much good unless the existing legislative framework is reformed to be harmonized with it. Also, if you step back from the beginning, the policy development process has to be designed in a way that connects with the participation I'll talk about next. But it needs to be done in a clear enough way so that people can understand what step we're at. I think a lot of times people legislative processes try to add all the steps at once. So they want to have basically what's called green papers and white papers, and what's a policy and law, different elements in one document, for example, and they release that to the public, and the public can be confused, and it makes participation really difficult. So this all I'm putting into this overall this area of legislative design, because really it's policy design too. It's the process as well as the substance. And then implementation is something I see a lot when in legislation reviews, is that just like I was mentioning with the beautiful new REDD law that doesn't have any connection with other sectors, you see a lot of times these nice legislation at the primary legislation level, which is a new forest law or a new law on agriculture or something, but there's no implementation with the executive branch, which is usually the one that develops the regulations in a more detailed manner to address the specific implementation of the primary legislation. So this needs to be done in a way that's also that it's adequate, it's appropriate for the national context. A lot of times, if countries are importing directly the legislative ideas from, for example, a colonizing country, then they won't work in that national context, perhaps because the different contexts, the different conditions. For example, if they're really rural areas, then certain types of legislation won't work from a colony that has very small colony that's not designed, where the legislation is not designed for a rural area. For example. Then enforcement, I've listed a bunch of things here that are important for enforcement, that for example, the penal codes, the judicial system are all up to date, and the data is relevant, and a lot of times it's really important to have mapping, maps, and understanding of what kinds of land uses are going on in different areas in order to enforce laws. The equal application of forest sector rules, so that the forest laws and land use laws aren't being just applied to the poorest, that are maybe easier to apply to, and then for example not being enforced adequately on actors that are more powerful, that may be more difficult to apply to. But I put this last little point here in terms of enforcement, that local community empowerment and participation is important for incentivizing compliance rather than relying on enforcement and stronger enforcement. So I think this is, if the better you have the land tenure situation and better you have the participation in the community empowerment, the less we have to rely on enforcement, because really it's kind of a last straw remedy to rely entirely on just stronger enforcement of laws. Next slide, Breen. So I wanted to, I had this little system here, which is, it's pretty simplified, but it's just a way to break down the types of participatory rights holders. I think a lot of times when we talk about multi-stakeholder consultation and involving participatory and procedural rights, it's assumed that everyone in the country or everyone should have the same rights. But I think that it becomes a bit arduous. It becomes too much to try to get everyone in the room to unless these are general issues like the development of policies and laws. When it comes to specific landholdings or specific decisions about certain areas of land, you can divide these participatory rights into control, consent, and consultation. Those with and this is just from the strongest amount of right to the weakest amount of right, so they're not mutually exclusive. But with people with the most control have the rights to the carbon capture and sequestration, and they would have the right to be compensated for whatever is taken from them out of those rights. Then they have consent rights, which is the veto power, but it's not necessarily financial compensation. And then consultation is, for example, people living nearby, but they would have a chance to give feedback, but they don't necessarily have the right to a veto or financial or other compensation. And the other issue here I think is important to think about with public participation is these three general principles of international law. Access to information, which includes both passive and active duty. So the passive duty is of states or governments, jurisdictions to respond to requests for information, but also an active duty to provide information to the public in a timely way in the language that they understand. So the passive duty in the REDD context is often inadequate because you have a lot of people living in remote forests that won't be able to go to the government and ask for more information. And even an active duty, if it's framed in a way like posting a notice in a newspaper, would not be enough. So it would have to be context specific to get the information to the people who would be affected by a decision. So this access to information can also be a challenge because it has to be balanced by the need to not raise expectations too high of communities about REDD Plus and about the benefits that may be possible, but maybe it'll be a little while before these types of benefits could come, and there are also maybe costs associated with REDD Plus. So there's that's balance, and this balance also is seen in the participation of decision making. I think there's a need to balance the efficiency of the process in order to not blockade REDD decision making with the need for participation. And in particular, there's the element of the issue of free and prior informed consent, which is really important to those living directly in an area that's directly affecting their rights and resources. And this can also be considered free prior informed consultation by some groups. But in either way, it should be limited to those generally affected by those decisions, as opposed to if it grows much larger than that, then it can kind of stymie the entire process. And the third principle of international law is this issue of access to justice, and this includes both the standing to bring a case. Standing is a legal term that you have basically the right to have access to a court to bring a case or an issue to have a court decide it. So this requires that the plaintiff landholder, for example, was able to show a claim that is cognizable, that is understandable, that you can make out the injury or impairment of a right. But this can be difficult in rural areas that REDD is found, that it usually requires some form of alternative dispute resolution mechanism, so that landholders living far away do not have to travel all the way to a court just to be able to bring a case. Thanks. And this fourth set of issues for national level frameworks, I'm phrasing this as national level. Actually, it pertains throughout REDD, but throughout any subnational and national issues. Actually, this is, I've loosely described it as crystallization of policy, but these are largely policy issues that are developed and then developed into substantive law that's relevant for REDD+. And I've kind of arranged them in what I think are the most important for legislative purposes, at least, to a little bit less important, but still, important enough to discuss real quickly here. In spatial planning or land use planning it's found in most countries. Actually, most countries have some type of spatial planning, but it's often focused on one sector, or there are conflicts between sectors. And this is just the idea of mapping out lands and assigning where the development will happen and where protection will happen, for example. But there needs to be a consistency across sectors, and there needs to be a harmonized way of mapping and planning for development and conservation and other types of land management. And there's a need with land use planning, there's a need to specify specifically for REDD where and who can conduct REDD activities, the priority areas for REDD, the planning across the sectors. If it's done together, then we can find synergies. And note just briefly that in federal systems, it's especially difficult to plan land use often because there's different horizontal and vertical levels that government agencies, and they may not be talking together as much as they need to. In institutional issues, this is also a huge issue for REDD legislation and institutional clarification. Because REDD is so cross-sectoral, there's many existing institutions that are relevant, and a lot of times countries develop new institutions like a REDD task force or a REDD special agency or something. So these need to be coordinated, and then there needs to be clarity of who's doing what, who's taking the lead, and then all the practical issues need to be clarified just as much, like the meetings and financial resources. With regard to the third and fourth topic down, I've split what could be thought of as the whole finance and benefit sharing package. There's one at the top level. There's receipt and management of the finance. So this often is comprises creating a fund, a national REDD fund and/or subnational REDD funds, and then there's the what lands and activities and sources are included on REDD, are eligible for REDD benefits, and then a way to link the funding to the actual emissions reductions and removals, and that can be a pretty complicated task. So it needs to be done in a way that's accurate but also efficient. In terms of the safeguards, this is a really important topic, but a lot of countries already have some form of safeguards in existence for land and forest areas, but these need to generally be adapted to REDD issues specifically, and a lot of times they need implementation. They exist maybe at the constitutional and the primary legislation level, but not at the regulation or secondary legislation level. So there may be decrees that need to be passed or be developed by the executive branch to make this happen. And it needs to be a common approach for safeguards across the country, but they can also be customized. And this, I think, a lot of REDD, a lot of countries could customize this, drawing on experience in terms of principles, criteria, and indicators type approach that you see from the from existing voluntary safeguards standards. And then finally, I put in here the issue of measuring, reporting, and verification, and accounting, and national registers. And this is all tracking, what activities and are going on, how it's being accounted for, and the credits that are coming from it. But these require really close technical and institutional coordination and the need to harmonize approaches here. We can proceed on. That was our national level issues. I think we had we'll have more covered more there in the at the national level than I'll have on the subnational. So I give you this little intermission slide, and which just to set you up for some questions here. Like I think it's important to step back and think practically. Okay, what does this all mean? That we develop such, especially if we spend all this time developing REDD-specific types of legal frameworks and legal issues, when we're still waiting at an international level for an international agreement to fund the national level efforts. So what can we do in the meantime? And that's why I think the subnational considerations are really relevant. They can kind of, the subnational level issues, subnational level initiatives can allow a link between the project and the national levels, and they can get countries on board able to do what they can in the meantime before they can do a complete wall-to-wall type national approach. They can build on existing voluntary standards and other initiatives and basically integrate the subnational and project level activities to the national policies that are going on. Next slide, please. Okay. So this is, I put this little picture in just to give you a brief schematic or just outline of the kinds of scenarios that are possible. This is taken from the verified carbon standard jurisdictional nested REDD approach, but there are many other ways that possibly that other approaches that are possible. I don't mean to draw too heavily on the VCS approach. It's just for simplicity's sake. If you look at the far left, there's a picture there of full project nesting, and the finance there only goes to the projects. But then on the far right, the finance goes both to the jurisdiction and the projects. So there, the far left would be more of a private finance scheme where the jurisdiction maintains reference levels and monitors leakage, whereas and does a kind of a minimal role for the jurisdiction. And the far right, the jurisdiction's doing most of the work. But there could be a mix of public and private finance. Yeah, and then, sorry, the jurisdictional in the middle, in the middle we just had basically a mixed sets of jurisdictional and nested approach in the middle. The finance going to both the jurisdiction and projects. So it would be a mix of public and private. Next slide, please. So the reason I bring this up also is I think it's important just to think about some of the new issues that would come up in considering subnational approaches. For example, how to address the treatment of carbon rights at different levels and across both jurisdictional, subnational, national type of jurisdictions. How to resolve the rights to credits between the projects and the government. The rights to develop projects or programs, and who has authority to regulate the forests. The liabilities for reversals of the carbon sequestration, and then resolving the rights between the different levels of governments to make sure that to clarify who is speaking, which voice is speaking, from which government or private developer. And there's three kind of themes here: the state, property, and the private rights. And this is relating to the treatment of legal title to land and carbon at different levels, like we mentioned. And then there's an interaction between private and public law. So the public programs and regulations, and then you also have private contracts and buyer-seller developer arrangements going on at the same time. And then finally, I think there's this need to balance the control, that the proper authority is vested in the right people, but then also to give the incentives to subnational jurisdiction and private initiatives to do what they can and to be creative. So again, this is just a little bit shown from a different way. The private law, the projects will generally deal with private law, and the project proponent and under the private law approach needs to establish the clearer title to land and carbon, and in order to have a clear have the credits to carbon. And then the government program, conversely, the government doesn't need to have the title and tenure figured out so well, because if you have government, for example, broader programs that are, if you think about cook stoves, for example, type programs, or programs where the incentives are restructured at a general level across the entire country or entire state, these don't rely on title to land or carbon. These rely just on changing behaviors generally inside the overall jurisdiction. So then in the nested approach, you could have both types of situations. You could have general government program and policies going on, programs and measures, and then you have the private projects with landholders changing their behaviors and the land, and that is more of a credit type approach. So, sorry, it's more of a direct approach, and then the issue becomes how to establish causality or attribute the carbon reductions to either the government or the private actors, and this can be a bit difficult in some cases to establish this, to figure out, well, which part of it was of the reduction was due to the broad government policy and which part was to a particularized project. Next slide, please. So, as we mentioned, there's different rights to carbon. Several ways of approaching carbon rights at the jurisdiction level, by legislation, for example, and the project level with a real property instrument, real property contract defining rights. But many jurisdictions are already developing arrangements to govern profit sharing in order to divide the profits or the benefits between private developers and the government for its part in, for example, establishing the jurisdictional baseline, establishing programs and measures. So there's a balance that's needed for the jurisdiction or the government to have the sovereign rights to be recognized, to claim part of the credits, but it needs to be transparent in doing so, and set it out clearly who has the rights to which part of the credits. When we reflect on the project-only world, for example, under the clean development mechanism or the voluntary market, there's less need for clarifying between those submitting requests for approvals and authorizations and representations, because they were less involved, and they were also there were designated operating entities, designated national authorities that were involved, and they had the singular voice to speak on these issues. In the nested world, this becomes a little more difficult. The approvals and authorizations, representations, because you have different entities or different levels that are submitting different parts of the scheme. For example, I've listed a few here: design and the boundaries, the baselines, distributing benefits. But if the upper level, general rules at the upper level has liability due to the actions or the lack of actions from the lower level parties, then it should also have the control and oversight over them. We can, let's get to the next one here. So I put together just a few in reflecting on the subnational approaches. If you think about some of the pros and cons, I mean, I think there's a lot of pros, and in my mind, it's definitely a way to get started. It's a way to improve the environmental integrity of not just focusing on singular projects which might have a lot more leakage, and also to build up so that we just don't have REDD legal frameworks and policies at the national level that don't have any actual capacity, that don't actually have anything going on inside them for the next 10 years or however long it takes to get an agreement at the international level. So we can build up to that point. In the meantime, there are a few challenges that the institutional, legal, and technical coordination needs to be a lot higher. And there are a lot more procedural hurdles than a simple, country level or project level REDD alone. So this tends to favor higher capacity developing countries, and you see a lot of examples from Latin America especially. And I think Chiapas, Acre have great examples, and they have a lot of lessons to provide. I had listed a few quick, pilot. This is lessons from some pilot work in Acre, Brazil, and I think it's important to use these cases to start learning about how maybe other jurisdictions could start building on these processes. The last slide. So, just a few final thoughts. I think it's important for each country to have its own customized approach and to prioritize and plan on their own approach. It would be difficult to say. I mean, even in this presentation, I don't mean to say that these are the most important issues for every country. Every country is going to have its own set of issues, and will need to look at it from their own perspective. But it's in general, though, I think legislation and regulatory reform it's an ongoing but dynamic process, and it takes. It's not possible to do everything at once, but it is important to prioritize and think about where to get started and what things will take a long time, what things will take. We can maybe do creative solutions for in the meantime, and what things we can focus on establishing a process that will take a little bit longer. And it's really important also to have this in mind, to keep in mind that legislation doesn't really do anything if it's just on the books, but it's not implemented. If it needs to have teeth, and the conflicts with other law from other sectors, for example, need to be resolved, or it will just kind of sit there and maybe not have the full mandate it requires. And and then this second section of the presentation here, when I talked about these subnational approaches, I think it's important to think about them, with a balanced perspective. It has a lot of benefits. There may be maybe some challenges. Maybe it's not right for every jurisdiction right now, but it's something I think we can all start learning about and thinking about as a way to build up from where we're at now. And that's it, Breen.
Well, thank you. Thanks for that great presentation. And at this point, we will open up the floor to questions for John. So please feel free to submit your questions through the panel on your GoToWebinar setup, and we will jump right in. So, John, to get us started, the first question, and as you answer this, I'm going to advance to this next slide so that people can see a list of resources that you shared with us on this topic. So I'll just let that sit there. But the question is it necessary for every REDD country to create a new REDD law? Should this be the top priority?
Thanks, Breen. Yeah, I think a new REDD law or just like in climate change in general, if you have a law addressing climate specifically, and possibly if you're looking at REDD, then a law addressing REDD specifically, it's a new area, and if the country wants to lend its gravitas to this area and also to speak with one voice so the entire government understands that issue, then it's very important. But I would add the caveat that I don't think that I think that a lot of times countries think that it seems from my impression that there's this idea that we've created the REDD law, so now we're done and we don't need to look at all the other legislation. But I think the new REDD law or a form of existing law should always be done with with a wide-eye perspective, looking at all the legislation and the implementing regulations that are relevant. Or it can't just be another tool on top of tools that are in conflict with it, or it needs to be done in harmony with the overall system. So yes and no.
Great, thank you. So the next question is, isn't the big problem in many REDD countries law enforcement, and should they all make this the top priority?
Yeah, I think there's a tendency to look at the countries, a lot of countries that are, prime contenders that are moving ahead with REDD, and to look at some of their history and to say, whoa, the law enforcement hasn't been so great in these countries. How can we kind of trust them to do, implement REDD projects? or programs. And I think there's this tendency to focus on law enforcement as the solution. And I think it's definitely important to improve the law enforcement, to make sure it's that the laws are better enforced. But I think that shouldn't kind of obfuscate or confuse the larger issue of clarifying the rules, and because first of all, if you have rules in conflict, then it's pretty hard to enforce things, but there's also this public participation aspect which is really important. If you get communities empowered and participating, but recognizing you have this balance, you can't get everyone in the entire country to be involved in every issue. Maybe some issues at the general level are relevant to the entire country, but particular areas will be relevant to those living in that area. But if the participation in the community incentives and the empowerment are improved, then a lot of times this can help. It's been shown that this can help the enforcement itself, and the enforcement is actually a lot easier of an issue to deal with.
Great, thank you. So the next question brings up a good, I think, point for you to clarify, and it is, does the presentation and this approach take into consideration the Warsaw framework for REDD+? Why talk about carbon credits if it's clear at this point that we won't have a market for REDD+ before 2020?
Yeah, no, that's exactly that's what I was trying to say with my focus on the subnational issues, is that we won't, we're waiting now until 2020, and actually an agreement in 2015 would, I don't know, maybe I'm a cynic, but I think it looks like a little bit might be a miracle if we get that in time. So the Warsaw framework and the slow progress on a lot of issues and the development of a framework in general for climate change, I think that's a real indicator, a real force for suggesting we look at developing from what we have at the project level into building up subnational jurisdictional approaches, building up from projects and focusing on areas where there is bleeding. As if you look at jurisdictions, if a country has an overall it's a large area, but a lot of the areas aren't really at risk. If we can focus on the areas most at risk in the meantime, and with the existing funds we have, then I think it's a way to get started and doing what we can with the finance that we do have. The Warsaw framework also is relevant to think about. It mentions that countries need to clearly, make clear who their REDD fund receiving agency is. So, I think a lot of countries are now thinking much more seriously about establishing a REDD fund, or making clear their overall framework for how REDD is managed, to make sure that there's that one voice that will speak on that issue. And also, the Warsaw framework, reestablishes again that we need to. Countries have to have safeguards in place. So I think countries are thinking more about safeguards. But yeah, we need to be realistic at the same time about finance and when we can expect it.
Great, thank you again with this pop-up. So the next question actually is a great lead-in from the one that you just answered. So this person asks, if you have more details on how safeguards, which exist at different scales from UNFCCC Cancun safeguards through to CCBA project safeguards, can be applied coherently in these nested systems of REDD+ implementation, and what the roles of legal frameworks might be in that respect.
That's interesting. I think that's something that will, if you look, first of all, you look at the existing pilots, I believe both of Acre and maybe Chiapas as well, Mexico, I think they use the REDD+ SES approach, which is principles, criteria, indicators framework. And so I think that's definitely, there's a lot to be drawn on from the existing principles, criteria, indicators approaches that are out there for safeguards. I think, however, that there will be, each country will customize how it's going to be able to nest the safeguards, or who will have who will have authority on the safeguards. If, for example, the projects will be developing the safeguards in a project-specific way, or if the country as a whole or the jurisdiction as a whole will have the authority. I think this relates a little bit to the issue of establishing who has the authority to speak and the different approvals processes, the different decisions. So I think that will be part of that, at least the speaking to the international audience on, these are our safeguards. That will come. It has to be a decision made within the nested system. So within those three levels, the project, the subnational, and the national level. And I don't think there's any clear answer yet as to who will have the authority overall for those types of decisions yet.
Thank you. So the next question is more of a, I think, big picture question, and this person asks, aren't we spending too much time in developing a legal regulatory framework for REDD instead of dedicating a big part of these efforts on the ground in the implementation process of avoiding deforestation?
Yeah, it's a good question. I mean, I agree in a way. I mean, not to say that legislation isn't important, but I would definitely agree in the sense that I think creating new REDD law, for example, or creating new laws that are in conflict with other law is a bit of a waste of time. And also if there's laws out there that could go a long ways towards getting towards the REDD type of goals, but they're not giving any implementation through the decrees and the regulations. So yes, I think implementation is important, but I think implementation of existing legislation, or even if there's new legislation, if you don't have that implementation, then I think you're not going to benefit from that law. So then you're right to say, well, law doesn't do anything. It's really all about. I'm not sure if you meant by implementation projects or what exactly, but yeah, the implementation of the legal framework is where if the rubber meets the road, and that's what's missing in a lot of countries. And also implementation, and also relates to the conflict between the existing laws. So there's a lot of confusion there. So that's more at the implementation level in my perspective. But maybe I see that more from a legal perspective. I still think it's really important. I think we're going to have a lot of emissions reductions, maybe a lot more than just discrete projects if we look at the overall jurisdiction and policies and measures. But these need to be implemented. So yes, I kind of agree. I'm not really sure I understand exactly.
Okay, thank you. So the next question asks, how do you envision the relationship between various national and subnational REDD Plus frameworks and the UNFCCC, particularly when it comes to using REDD Plus as offsets to GHG emissions elsewhere, such as in California?
How do I see the national and subnational levels relating to each other?
Yes, so how do you envision the relationship between various frameworks?
Oh, well, I mean, the UNFCCC already established that countries need to move to national level accounting and overall management frameworks for their REDD programs. But in the interim that countries can use, can have subnational approaches. So I think we're definitely in that interim period right now. When you mentioned California, I mean, obviously in the United States, there's no way we're going to have climate legislation for a while, it looks like. So California is definitely leading the way, and that's kind of our subnational approach. And I see that as relevant to other countries too, where you have the subnational kind of pioneer leading the way. Acre is a good example in Brazil. They're showing possibilities for what is possible, how it's possible to do these types of programs. And you mentioned offsets, and yeah, I mean, I guess a lot of REDD is the way it's envisioned. It's there's the offset perspective, and there's also the general funds and for forest management. I think right now, because we're in this interim period, I think offsets at the private, to get private finance in there, offsets are one of the big ways for getting private finance in there. And it remains to be seen when we talk about REDD finance at the international level. There's a lot of well, the U.S. in particular is advocating for a mix of finance, every possible finance measure there is, and then you have the other side, maybe least developed countries that are advocating more for just pure public finance. They don't really they don't like the looks of offsets, well, many of them. So it's still unclear how that will be resolved, maybe that tension. But I think offsets seem to be, in the interim, they seem to be important, especially for subnational types of approaches.
Well, I think our next question, you've touched on it a bit, but the next question here is, can you provide some examples of effective REDD legal frameworks, and what are the key factors of success in those? So you've talked a little bit about ACRA and Chiapas, but can you dive in a little deeper on those?
The key, just not specifically national or subnational, right? Just REDD
legal frameworks that have been effective, and if you think there's anything in particular that makes those particularly successful.
Yeah, well, there's one example that I didn't mention that it's also another. It's more of a starting at the policy level. I think Ecuador is a good example of a really good foundation. They kind of have this foundation where they started with a constitution, gave rights to nature, and they gave legal force to the government to protect the rights. Then the communities are given the right to benefit from the environment. I mean, these are very broad. It's a constitutional level, but then they also reformed their Environmental Management Act to coordinate all the different legislation and regulations. Then they have a clear goal of a 30% reduction in deforestation by 2013. So I think all these issues, starting, this is more at the foundational level, but if you start putting out the clear goals, putting out how you're going to establish the rights and benefits, and then start harmonizing the different sectors' laws and regulations. Then then it goes, and you have to follow through, though. Just like the other person said, so what about legal frameworks? What about implementation? And yeah, that's really important. If you follow through on the design of and sectoral coordination, you follow that through down to the lower level, and you have all the implementing decrees that are necessary. Yeah, those are probably, and then of course all the way through. These are, all the way through. You need to have the public participation. It's really important to balance that, of course, in a way that is efficient as well. And then I listed these other issues that are going to be different for every country. In my fourth slide I think it was about, where I had listed. I called it crystallization of policy issues, and those will be different for each country. But I see land use planning and institutional arrangements, finance and benefit sharing, the receiving finance and then distributing it, safeguards. Actually, they're all important for every country. There's just going to be, it's going to be customized, and some may be in more need of help than other countries on different issues.
Well, thank you.
I think all those issues are really important.
Wonderful. Well, and we're coming to the end of our time, so I think we will call that our last question. And just to run you through these resources here, again, to remind you, we will be posting, people have asked about a copy of the presentation that will be available in PDF form within a few days on the REDD community site. And again, you'll receive the link to where you can find that in your follow-up email. And these resources are also posted there. And just another list of resources from the WWF side of things. You can find an archive of this and other learning sessions at that URL. And again, I won't run you through all of these specifically, but thank you again to John for this great presentation. And we did have some questions that we didn't have time to answer, so we will work with John to get as many as we can answered on REDD community, and we'll post those answers there for the ones we weren't able to touch on today. And again, you can always keep in touch with us, with the WWF team here on Twitter, through our website or on email. And then thank you again, and here's John's contact information if you'd like to follow up with him. Thanks to everyone for joining us today. Thank you to John, and we will see you at our next learning session next month. So with
thanks,
that,
Breen, and thanks, everyone.
Thanks. I'll bring us to a close, and we'll see you next time.